Greetings. This is Tex with thctrust.org. Visit the website, create a free account, and you can join the premium subscription group, and that'll give you access to all the templates. Let's say the majority of the templates, with the exception of just a very few things. Anyway, it'll definitely give you access to the templates that we're going to discuss in this lecture right here. And we're talking about the Uniform Residential Mortgage Satisfaction Act. And as you see here on the screen, it's drafted by the National Conference of Commissioners on Uniform State Laws. So my understanding what this is how you have like a uniform probate code, uniform commercial code, actually a better association would be like Prop 215, which is like the marijuana bill that they're starting to pass in several states. It starts out as a bare bones bill, like a template, and then it goes to the state, and then they start fine tuning it to meet their policy or their objective, or their goals. Similar to the same thing we're doing at thctrust.org when we deal with our status, or our status correction, or our commercial status correction. So I pretty much provide a template or blueprint, that which I've done for myself, and then encourage you to adapt it to your personal situation. So that's the same thing how these things work, but at the end of the day, these things are supposed to be passed through the Senate and the House, and then they get enacted into law. If they pass through that threshold, which has been set by your state and federal constitutions of what has to happen for a bill to become law. Anyways, this, as you read about it, you will find has been enacted in several states, but not in this raw form right here. So if you really want to kind of see what your state has, and what is this about? This is about finding a way to satisfy mortgage deeds that's on the property records. Ideally with the splitting of the promissory note, securitizing mortgages, secondary market, selling notes and things of the such. The old way of doing things, actually this is like a band-aid to address the old way of doing things, which requires the secured creditor or whatever to record some type of satisfaction. Because there's really no more secured creditors. This is kind of our patch. This is an administrative procedure, which is a patch to the fact that under the statutory commercial system, they've been allowed to sell and trade notes and things like that. So this is just a remedy put in place because in many instances, many of these records was lost. There's really no clear chain of title. They don't know who's a secured creditor or not. However, it still becomes important that some type of instrument showing that a satisfaction of that deed gets indexed in the record. Now, this is very important to know that everything deals with indexing. Indexing, let's say, puts indexing kind of ledgers a liability against an asset, that asset being your legal name, trade name, and or the legal description of the real property. So it's really important that, so that being said, it's also important to understand that every time something is recorded or filed into a county, that's a form of some type of banking transaction, because by definitions, those are financial institutions. And those are the type of financial institutions where money is created. in a secondary market, in different bond markets and stuff. That is one of the interfaces in. It's just like walking into a bank to deposit your checks. That's one type of financial institution that you probably do normal business with. And then there's a whole nother type of financial institution going on, which both have the objective of creating money or monetizing things. But anyways, that's going on. And every time papers are getting recorded with the clerk, acknowledged with the clerk, deposited, things are getting ledgered. And those ledgerings, from my understanding, go against the trade name, as I said before. Trade name, because some kind of way the man's connected to the earth. So there's some kind of way, using the trade name to ledger claims against the property, or let's say the real property. And I'm not trying to suggest that we're property, but I'm talking about the tangible thing. Intangible claims tied to tangible things, meaning the vessel, the body, which is they're trying to bond to the trade name, and then you have the earth, which they're trying to bond to the legal description, the legal property description, when it talks about when it goes into the leaps and bounds, or the quarters, or however they name it. These are the assets held in trust, I guess you will say, to which they are creating their commercial fiat claims, their debt obligation money, based off of those assets, so to speak. So I was saying all that to say this indexing is what's going on. There's an indexing, and it has to do with the creation of the books, the balancing of the books, and the ledgering of books, also the creation of the money, the opening and the closing of accounts and things of the such. So I'm not professing to understand all of it, but because of different things I study, certain things become apparent. But I also know it's apparent, and it's important to some type of way satisfy any outstanding obligations. So this provides a template already set out, an administrative procedure for doing this. Now, in my mind, I don't so much worry if my state hasn't enacted this exactly as it's put here. I don't even worry if my state has enacted it at all, because the underlying principle of an administrative procedure, the authority of what they're explaining in here, believe it or not, doesn't come from anything within this document. This is not an authoritative document within itself. The authoritative is the law. It's just the law that deals with consent judgment, the law that deals with failure to respond, right? And if you take this administrative procedure that they presented, especially if you add just a little bit more to it, with the even stronger points that that the person who adopted this, the persons that wrote this, I'm pretty sure that they know. But if you add the little bits that you already know they're not going to respond. And the force and effect of that is what's known as a judgment by consent, or a consent judgment. And of course, this is under the common law, and it is the judgment. That's what it is. So I'm saying all that to say this: you can use this right here, this draft, because again, remember, they drafted this. You can use this draft right here to be the governing document governing your private administrative procedure that you're going to use to perfect a consent judgment. Backing that affidavit of satisfaction that you're going to put on the record by following this administrative procedure. So when you get into this, and if you decide to read this, especially with what I just said here, now you can better understand why you don't have to be bent out of shape if you can't find a satisfaction agent. Because this talks about using a satisfaction agent as a go-in between the parties. Look at the last video that I did on this, and it'll give you more about how this works. But what I'm trying to give you right now is just some oversight of administrative procedure, how you can use administrative procedure with this that they've already laid out for you. right? Because what is your administrative procedure anyway? It's the courtroom proceeding, right? It's a claim that has been filed. It's giving the defendant or the other party, whoever it may be, the opportunity to respond. It's giving you the chance to further rebut or challenge their response, or address the matter if it's an improper response. It's the same thing that goes on with courts, except for it's called motions. Motion to dismiss. What they're saying is irrelevant. It's kind of like saying. But either way, what I'm trying to show you is a judgment is a judgment, whether it's a public judgment or a private judgment or this type of judgment or that type of judgment. At the end of the day, it's all about a judgment. And what is a judgment? It's consent. A judgment is consent, agreement between the parties. And it's so funny because if you look, and you can't see it, but I'm going to read some things to you. Actually, I'm not going to read it to you. I'm just going to tell you. You can look it up. In my Black's Law Dictionary, the 8th edition, look up judgment by consent. And then they take you on a goose chase. So you know it's something good. When you look up judgment by consent, they tell you to go see agreed judgment. And then when you go all the way over to agreed judgment, there's nothing else there. They just tell you, and that's what I'm saying. There's nothing else there. They just say go see agreed judgment. Then you go all the way to agreed judgment, and there's nothing else there. They say go see judgment. So what's that telling you is a judgment by consent is a judgment. Seems to be the only judgment. An agreement between the parties, that is judgment. So that's all administrative procedure attempts to do, to certify the facts that were agreed to by the parties, by the silent consent, tacit acquiescence. Now, this is why your records have to be precise. And one of the things that you have to work your way backwards, meaning, for example, if the end result of this, of what I'm trying to accomplish, is to remove all liens and encumbrances from my title, then at the end of the day, that's quiet title action. So I've talked about quiet title action before. This is part of that strategy leading up to it, the administrative processes that you may do first, right? So, but keeping in the thought of what I was talking about is you want to work your way backwards. So I would start with quiet title. What are the elements, what are the necessary elements in order to have a quiet title action? And to do that, you can Google elements of quiet title action or elements of ejection. Whatever it is that you're trying to do, Google the elements of that, and then you will see the right recipe. And these are the facts that you need to establish in your administrative presentment process. You need to establish that their silence tacitly acquiesces to every individual fact of the recipe that's necessary to get the in consent judgment that you want to be enforced. So thinking in terms of what is the consent judgment that I need all public fiduciaries to enforce. Think in that terms when you write. This is why your writing has to be somewhat neat, because at some point you're going to be depending on some other public fiduciary to enforce this. And I will get to that. So right now, just this worry, let's kind of think in terms of working our way backwards with this thing. So thinking of that, when you're looking at this Uniform Residential Mortgage Satisfaction Act, the objective of this act within itself is to record that satisfaction, right? The satisfaction, and to nullify that deed and basically release that bond, that obligation that's indexed to your trade name, or further indexed to a legal description or something like that. But anyway, so there's an importance there, there's a significance there. So that being said, whether you use a notary as a satisfaction agent, whether you just use a third party as a friend, and you have to go back and watch the other video if you know what that, to know how that position rolls. Whatever you do, make sure that your documents are very precise, they're very neat, they are professionally typed, do the best that you can as if an attorney wrote them, because there's so much, because a lot is going to work in your favor. First off, you don't want any employee, they don't have the authority to, but you don't want them to. I know this happens to some people. It doesn't happen to me too often. but you don't want them scrutinizing your document saying, oh well, we can't record this because it's got to come from the bank, or it's got to come from they have no rule, no law, no regulation, no statute, no policy that they can point to that suggests any of the things that they start suggesting there. They're practicing law, and they're not supposed to do that. So, but even though you know that, if you want to avoid that battle altogether, just make sure you cross all your T's, dot your I's. This is why I spend a lot of time putting professional, at least the best that I can do with the time that I have, templates together so you can avoid that scrutinization and get your things recorded. I usually don't have the problem of not being able to get things recorded. And this is really important, why you have to learn how to use a notary presentment or how to use a third-party witness and hold people liable. I've been talking for a long time on thttrust.org, so it does surprise me sometimes when somebody that's been with the organization for a long time is like, they would not take my paper or something to that effect. And I be thinking, like, you still have not understood that when it's very important, you use a notary presentment so that you have a notary certificate of service, so there's no such thing. Like, that's kind of goes without saying, right? Anyway, so a consent judgment is important because all judgments, all properly cured judgments, have to be accepted in every cognizable jurisdiction. There's the Uniform Foreign Judgment Enforcement Act. There's the then you can also go into the Act of State. There's that Act of State document. It was on the internet a couple years ago. There's a couple things out, I think 22 CFR in there, but when you look closely, any affidavit by any of these persons, the so-called persons with the estate, when any of that stuff is authenticated at the Secretary of State level, it becomes an act of state. So that's why you have, anytime you're going and doing things, getting things authenticated, or getting, even birth certificates, getting them authenticated, getting affidavits authenticated, you should not be doing that stuff if you do not understand what you have written into the document that you are authenticating it. If you're rushing against time, the thing I could tell you to do is work on your diet, work on yourself, so you'll live a lot longer and time would be less of a factor. When you do your paperwork, make sure it's professional. There should be no difference between you or some attorney in fact, or some attorney that you don't even know is working for you, doing it for you. Right? Your stuff should be precise. And so you have to read this, understand what's being said in this document, and then transition this knowledge into Administrative Procedure Act, so that you can turn this process right here into a private administrative procedure that ends in a document certified by a notary known as a consent judgment. And when you get the notary seal on that consent judgment and you've done a thorough process behind it, you run it up through the Secretary of State's office, and then you get that big seal on it, and then that becomes an act of state. And then it becomes an active state, and further, the consent judgment is a judgment. It is a judgment, and it must be acknowledged and recognized in all jurisdictions. I've done this before, folks. It's about being meticulous, believe it or not. That's what you have to do. You have to be meticulous, and it's very important that you work your way backwards. You have to think beyond your opponent. Look at their trends. What are they trying to do? What doors are you going to have to close for them? Those are the facts that you want to prove through your administrative procedure, so that you can get the big stamp on that judgment, res judicata, stare decisis. I probably said that wrong. I probably said it right. So listen, and that's the authentication or apostille process. Now I'm saying these things, so please don't just rush out and do this stuff until you take your time and research every part. And don't always ask me, should I get an authentication or an apostille? Why would you ask? So, now I'm at the determination. I ask people, why would you ask me that? I have the same information that you do. I have to go research what the difference between apostille is and an authentication. So that's how I make my determinations on things like that. Should I get the apostille or should I get the authentication? I base it off of all the research I do, what makes the most sense. I usually don't ask somebody else. I don't depend on their determination. I just start making my own based off of well qualified research, of course. Yes, sir. Anyway, okay, let's see. So what else did I want to say? Okay, yeah, so start seeing this. And as a matter of fact, you could take your administrative procedure, because this has the template affidavits in it. And then also, I got my templates that I created a while back. I'm going to add, if you get this with the email, these will be on thctrust.org. But what I was going to say is, you could take the instructions. See, like, you read this right here. This tells you, short title, definitions. This is important. Listen to what I'm saying here. Notification, manner of giving an effective date, document of rescission, effective liability, wrongful recording. If you take all of this, this is all the instructions. Remember I said we're going for a consent judgment here? Whatever you say the private process is, that's what it's going to be. If you want to better understand this, go back again. I don't care how seasoned and veteran you are. Trust me, it's going to permeate your mind. You're going to see new things. Go back and watch the administrative procedure stuff taught by Creditors in Commerce. It's a video on thctrust.org. Go back and watch that. And you're going to see that this is your private judgment. These are the proceedings right here. These are like your rules of civil procedure, except for it's in your private court. So these are just your rules. They're the governing documents. They're the instructions of the court. It talks about notification, how notification has to be given. That's kind of like your service of process. It's private though. Document of rescission, effective liability. It has definitions in here. It has everything. So this is your whole procedure right here, all the way down into the affidavit of satisfaction, the content, the form, the effect, the agent, all the way down to the judgment, right? The effect, that's the judgment when you get into that. And so you can actually take this, the definitions and all of this, and when you start communicating with the I believe you would do this to the alleged servicer who alleges to be a secured creditor with no documentation and no proper standing, and you would probably also do this with the original lender who you have to look at, because most of the time these days that might be some type of trust or some other entity that's no longer doing business. But either way, your administrative will have to procedure will have to go there. And by the way, the thing that I'm not really saying in here is that you really definitely are going to have to make this private. I would suggest that you do. And what I'm talking about is if you've done some type of private set-off process, or if you're doing one, or if you are operating on another side of a ledger, then you're going to have to beef up this affidavit that if you're going for a consent judgment. What I'm trying to say is what in here alone is not enough. So that's another reason why I created the master process that leads to the quiet title action. That's not done yet, but now you can kind of get a flow of what I've been working on, and you can find all this stuff at thctrust.org under the mortgage menu. In fact, I'm going to go over there after this and try to spend some time organizing it. So what you'll see is this Uniform Residential Mortgage Satisfaction Act, whether you use this process precisely or whether you do a private administrative process and include this in it, ends in the satisfaction of that deed or that security, releasing that bond obligation. That's the intended effect that you want.